Well, thank you so much for being here this evening. I'm understanding inaugural lectures as an opportunity for me to share my reflections on my academic journey with you, and in fact, also to express gratitude to many of you that have walked the path with me and supported me and have bear with some of the innovative and sometimes experimental steps I've taken along the way. So it's an opportunity to express gratitude. Some of the people are here in the room. Some are not, but I know are here in spirit. And it's been a tremendous journey, and I would not, I think, have made this way all alone, for sure. And I would like to take this opportunity to think about what I think has been my contribution so far and the reasons why I'm so passionate about what I do. And also to think about where we're going next with the One Ocean Hub, and where I think we have research that can be shared with others and a journey that can be very much open for others to take with us. So what is it? I was trying to think, about my path and where I started from, and what are the things that have kind of a red thread throughout. When I did my master dissertation, it was about whale sanctuaries. My PhD was about corporate accountability and international law. And my recent research has been on fair and equitable benefit sharing in the context initially of bio-based innovation. So the themes have been quite varied. But I think what I've realized was a common thread among them was areas in which international law was struggling to emerge, where there were on some sides a demand for more international law, for stronger international law, for more innovative international law, and on the other hand, some resistance to that emergence. And I think that was really insightful in looking at what are the expectations that we have about international law, what are the limitations that we feel are hindering progress, but also what are the promises the international law holds. And with that, a reflection about the role of different lawyers in engaging with those difficult discussions. And it's really about then understanding and engaging with the relationship between international law and different conceptions of justice. And this is, many of you will know, I'm not really a person that has flourished in terms of theory. I'm more of a pragmatic lawyer. But I have come to learn how important it is for practitioners and for lawyers engaged in different lawmaking processes to reflect on theoretical discussions about justice and how that reflects into our own work. And really thinking about different dimensions of justice and what they help us shine a light on in terms of where we are with the development of international law. So thinking about the distribution of resources and opportunities, participation, transparency, the recognition of different forms of knowledge and different contributions, and with that, owning up to forms of discrimination, disrespect, or stigmatization, as well as corrective justice, how we live up, how we own to past mistakes, how we understand what went wrong before, and how that then needs to be forming our understanding of the role of our own reflections on international law and international environmental law. And what I've tried to do in my own work, climbing on the shoulders of those that have done all the thinking on different dimensions of justice, but also all those that have worked in the field and worked side by side with those that have experienced injustices, is really looking at the technical details of the law and see how they may reveal implicit choices about certain dimensions of justice that are addressed and which dimensions of justice maybe have fallen through the cracks or have been de-emphasized. Usually in international law, we do speak of fairness and equity. We might not speak of justice directly, but we never really openly and systematically engage with the kind of justice we're pursuing. We often leave that as a not fully enunciated and investigated notion. We assume that we are all working towards a certain notion of justice, but we may well be working towards different views of what justice is and how international law can develop to address it. And with this idea of discovering maybe the implicit assumptions in how international law has developed, I've become more and more interested in how the interpretation of existing international law can help us to negotiate in practice, understanding of contextual justice on a case-by-case basis, how different actors, how their expectations about the law come into play, and whether or not international law as it is at a certain point in time can respond to their demands, and can help different actors that maybe are having very divergent views of justice in a particular context to come together to the same table and engage in mutual understanding. And in that kind of reflection, that is where I think the title of the lecture comes from, and my particular interest in the interface between international biodiversity law and human rights, and how that interface, how these two areas of international law can help the lawyers engage in a discussion on justice with other lawyers, but also with other colleagues in other disciplines. And really because, I mean, for many lawyers feel actually uneasy to talk about justice, and many international lawyers are familiar with the understanding that justice is found within the law. We can't bring our own subjective understandings of justice into the law. We have to look into international law and understand how justice is encapsulated in it, and how different ways to understand it and put it in practice can contribute to that idea. I want also to reflect for a minute on what Neil Walker has recently written about the gap between global law and global justice, how it is quite difficult for lawyers to engage in a discussion on justice. And that's because both our own background, our own legal education, and sometimes our own personal inclination may make us be active in a certain aspect, but not necessarily having certain blind spots, let's say, that can make our work not necessarily fully engaged with those debates on justice. And he identified three profiles of global lawyers. One is somehow the classic black letter lawyer, maybe the hard-nosed lawyer, who's very pragmatic, looks into the details of the law, but can be quite detached or even impatient, in his own words, with the broader implication of law, and sometimes maybe disregard what can be the dark side of law. Another kind of lawyer would be a radical critic, so very helpful in looking at where the law falls short vis-a-vis certain understandings of justice, but who may, in terms of his own or her own blind spots, be a bit fatalist, lose faith in the capacity of law to really work towards justice. And finally, there's the idealist, and maybe I identify with that, the lawyer that still has faith and hope that the law can be a steering force for justice, but who runs the risk of becoming utopian, of not really looking enough at where the law falls short, or not particularly looking at the practice of law, the details of law that may respond to that ideal. And I think what that speaks of, what was really interesting for me reading this piece by Neil Walker, was really the understanding of my commitment to collaborative work, the fact that we need all these lawyers, all these different legal minds to work together, to engage in a dialogue and inform each other's work and help to see each other's blind spots, but also support each other's research, having both that understanding of the practice of the law, being very pragmatic about the real workings of the law as it is now, being very critical and bringing in maybe elements outside of the law to really question to what extent international law in particular is really supporting a certain notion of justice or multiple notions of justice, and the idealist to work with them and help keep the hope going and maybe finding solutions that may be well buried perhaps in the existing law. And I think this probably the combination of my interest in the role and the limitations and the opportunities of law, and the fact that we need more than one brain to really go to in depth in analyzing those limitations and opportunities, I think is what has very much formed my work, and particularly the Benelex project, which is the one I want to share findings with you for this lecture. And this is where, in this project that has lasted for 5 years, where some of the colleagues here in the room have contributed, and many of you also have provided inputs and suggestions, has been really, I think, the cradle for my own understanding of the importance of the relationship between international biodiversity law and international human rights law. I'll just say a few words then about biodiversity. This is an area of environmental law that many of you may be familiar, but it still remains a concept that many may feel quite contained and quite limited. We think about protection of nature and protecting pandas or whales, but we still have, I think, not necessarily a very broad awareness of how important biodiversity is for all really dimensions of human well-being. And it is becoming now, the science is becoming much stronger, and I think as lawyers and many activists are also becoming much more systematic in explaining how the variability of life on Earth, from the genetic level, microorganisms, pollinators, top predators, and even the existence of whole ecosystems, forests, wetlands, how all of that has deep implications for us, some more short-term, some more long-term, for the foods we may have access to, for our own human health right now, but also in terms of future development of medicine, for instance, for the quality of the air we breathe, for the cycles of fresh water, for climate change. So there are innumerable relationships between healthy ecosystems, a variability of life on Earth, and our own existence. But they're a bit more, the relationship with us may not be as direct as how we can understand, for instance, air pollution and our own health. And some of these connections are more indirect or are almost multi-scalar. Some of the damage to biodiversity may happen very far away from us and have implications for us quite down the line. And it becomes very difficult to feel that connection, to be aware, to be alarmed about the loss of biodiversity. Within that, my attention has really focused on the Convention on Biological Diversity, which is actually an international treaty that not many lawyers have particular sympathy for. And this is because if you read the text of the treaty, it is quite soft. The language is very open-ended. The obligations are not clear-cut. There's no teeth to most of it. There's no compliance systems. And a lot of the activity that has occurred under this treaty, regular meetings of parties, have developed further guidance. But even within that guidance, we find what's called constructive ambiguity. There's a lot of flexibility that is left for member states to navigate their obligations in terms of protection of nature, let's say. But of course, what weaknesses can also be strengths. And part of my work has really been looking at, well, what are the advantages of this, maybe at first sight, dissatisfying treaty? And one is flexibility. So the treaty is so broadly framed, they can actually almost work as a catch-all regime. It can address many issues that were not even present in the minds of its drafters. It has been able, in a very timely manner, to discuss new and emerging threats, not only to biodiversity, but more general threats to the environment. And it has done so in a way that is very transparent and participatory. The treaty counts 196 parties, so it's really global in scope. But I think what makes it even more interesting is that in the meetings of that treaty, many other non-state actors are able to interact with governments, to suggest text, to suggest whole new themes for action. And different ideologies as well are not only discussed within those meeting rooms, but they also emerge in the consensus guidance that is eventually agreed upon in that forum. And I think that is quite distinctive from many other international environmental agreements and processes that I'm familiar with. So in a way, what the Convention on Biological Diversity offers is a forum where we have the open dialogue as a basis for international cooperation, and a place where different worldviews are exchanged, and they may be encapsulated in a basis for international cooperation. At the same time, because of that openness to dialogue, the convention also is a site of resistance, and a site where maybe resistance that in other areas of international law you may not become aware of, the reasons for resistance come to light. And this is again quite interesting from an international human rights perspective. Certain issues and particularly government position in relation to how they understand human rights, how they understand the ways in which human rights may affect their own domestic regime and how their constitutions may interpret in different ways human rights. All of that comes to light in those discussions in the context of the Convention on Biological Diversity, particularly in as far as indigenous peoples' human rights are concerned. Other ways in which resistance comes to the surface is about limiting the subject matter of the convention, limiting its reach into issues that were not in the mind of its drafters. So the convention has been discussing more and more about climate change action and how climate change responses may actually be detrimental to the environment and possibly to human rights. It has discussed aspects about new technologies that do not find immediately another obvious home in international law. And often the response of some governments and other actors who were resisting to that desire, to that push, were either trying to push the issue elsewhere or saying, well, we can address it, but in very voluntary terms. And particularly, there's been a significant resistance to embracing rights and human rights terminology in all those decisions adopted under the convention. And this is the reason why the whole relationship between international biodiversity law and international human rights law was hiding in plain sight. There were obvious areas of synergy and overlap between the two, but there was also a resistance to have these different areas of international law to clearly speak to each other and speak in a common language. And this is why I think, in a way, biodiversity is a bit of a latecomer in an otherwise well-developed debate on human rights and the environment. And it has, I think, in looking at that, actually growing understanding of that relationship. There are some interesting surprises that also speak to the notions of justice I referred to earlier on. On the one hand, there's a surprising hidden contribution, original contribution of the Convention on Biological Diversity to the progressive development of international human rights law. So there are new concepts or a deeper understanding of concepts that are already encapsulated in international human rights law, but have not necessarily been fully fleshed out or fully understood in their operative value, particularly in the context of environmental governance. And that may have to do with very technical areas that, for instance, concern the creation and management of protected areas, the planning of major natural resource development projects, but it can also have to do with bio-based innovation or non-commercial research more generally. And so what I would like to do is to address two areas in which Benelex, our project, has been able to shed some light on this relationship. One area, I think, is one where, as we were progressing with our own research, international developments have confirmed some of our own intuitions, and when we were able to contribute with our research to clarifying the relationship between the CBD and particularly indigenous people's rights. And another area, which is the right to science, is an area where I think my research has been more speculative, but has quite a lot of promise in terms of thinking of also the next project that we'll talk about, so the One Ocean Hub. And before I move into these two areas, just to say why I think understanding the relationship is important. On the one hand, human rights, of course, provide maybe a stronger, clearer legal tool to address certain issues and protect certain groups, but they remain quite abstract, and particularly in the interface with environmental governance, they don't necessarily go to a sufficiently clear level of detail in terms of what are the concrete steps that we expect governments to take to respect human rights in the context of the protection of nature or in the context of developments, be those extractives of research, they may threaten the environment and have also human rights implications. On the other hand, I think biodiversity, international biodiversity law, as I said, because of that resistance to engaging directly with human rights language, also meant that it hasn't quite clarified enough the margin of discretion for governments. It hasn't really clarified what is the minimum content of obligations. And it has left, I think, important aspects, particularly of procedural justice, the need for strong laws, the need for effective remedies, the whole aspect of justiciability is really often left unaddressed in the context of international biodiversity law. It's often referred to as good governance and as concepts that we think are good practices, but not as a matter of an international obligation. And so the understanding of how these two areas of law complement each other really also clarifies the legal strength of international biodiversity law and the fact that human well-being is not just a broad concept that international biodiversity obligations aspire to contribute to, but it's actually a matter of international human rights law. So how did that then play out? How do we put this more abstract thinking into practice? Some of the work that we've been doing is really looking at well-known issues of developments in traditionally owned or used lands and waters by indigenous peoples, but also by other local communities, and how, while we have clear understanding from international human rights law about the possible rights that can be affected and actually are, unfortunately, on a regular basis violated by certain modalities of development, we still are quite unclear about how things can actually change in practice. We're familiar with what the steps are, but we haven't really been able to change practices around the globe. And the notions we focused in the Benelex project was that of fair and equitable benefit sharing, which is not really the weapon that international human rights lawyers would engage with. And it's actually looked with some suspect, because in fact it seems to be a notion that's used in a logic of exchange, of persuading indigenous peoples to renounce to their rights, to limit their rights in exchange for certain benefits that can make up for limitations to their own opportunities. And in effect, fair and equitable benefit sharing is a notion where, once again, the international community has not engaged in clarifying, well, what is fair, fair to whom, and according to whose values. Most of the emphasis has really been on looking at, well, what kind of benefits can be offered, and are they sufficient to make up for certain limitations to the uses of traditional lands and resources. So the research we've engaged with was really looking at the ways in which, in understanding the connections between indigenous people's rights and the CBD, we can find that additional level of detail that really fills the gap between an aspiration or a general abstract obligation and a practice that you can point your finger at and really assert, well, this is at the standard required, or this is below the standard the international law requires. And also thinking more strategically about how, once you make those connections, the kind of arguments you can make to challenge substandard practice. So one of the arguments we have developed, and it was really based on one piece of guidance that the parties to the Convention on Biological Diversity agreed upon, these AQUECON guidelines that have to do with environmental and sociocultural assessments of potential impacts on indigenous lands and waters. We're really saying, well, if we think about sharing benefits as part of how the process of proposing a development is, then we're really moving away. We need to move away from that logic of, well, damage control, the assumption that the development will go ahead, there'll be negative impacts, and the effort is all towards limiting the negative impacts and compensating them. And rather, what these guidelines suggest, by looking into questions of indigenous people's understanding of the resources, of their relationship with them, how their language, their culture, their intergenerational relations are shaped and part of their understanding of nature, how all of that needs to be engaged with to understand a whole different notion of benefits, and engaging in a discussion across worldviews about whether or not there may be potential positive developments, implications arising from a proposed project on their lands. So what that means is that we're, first of all, broadening the scope of those assessments, really bringing in indigenous methodologies, but also really opening the space for a dialogue across different worldviews. That also means not really using those assessments to present a predetermined set of development options. Really saying, well, what we need here is actually a discussion where we set the terms of the debate of this proposed development across cultures, and possibly with very radically different views of what nature and development and sustainable development is. The other insight was really thinking, well, this actually says a lot about consent and when and how indigenous peoples may freely provide their consent before a certain development occurs on their lands. And again, this in practice is always seen actually in attention. Consent is seen in attention and threatened by benefit sharing, because it's that idea that, well, the moment you start discussing what kind of benefits you may expect from a development, the assumption is that you're already on the path towards agreeing to it. And it is, again, there's quite a lot of empirical evidence that shows that this is the dynamic in practice, the negotiating dynamic that many communities face in engaging private developers and relevant parts of government. But again, thinking about it in the interface between these two elements and thinking, well, if there hasn't been that discussion a priori about different views of what development is and what benefits, if any, there may be, consenting is no longer in a logic of exchange. What we are looking at, and this is some of the further developments under the Convention on Biological Diversity really portray, is the idea of an iterative dialogue where we try to build a partnership. So where the exchange is not really geared towards a one-off green light for a development, but an engagement that's based on respect, recognition of different forms of knowledge, forming a collaboration among different actors that may have different stakes around a certain project. And so the benefits are no longer just a question about monetary and non-monetary, which is often what is discussed, and which is often something that leads to unsatisfactory agreements. And it's actually a false dichotomy, because all those benefits that are considered non-monetary, so for example, capacity building for those communities, recognition of their knowledge in certain processes, all of those have costs and require resources. And what has emerged, particularly in the case law under the African Commission on Human Rights, is really that what we're discussing here is control over resources and the support that may be needed to communities to exercise that control with a view to fulfilling their own view of their lives. And so the benefits really have to be something that strengthens that control, not something that is given in exchange for giving up that control, even if maybe control that communities may decide to share with others. And really also the realization that that control is difficult to exercise in the context of complex regulations that may apply in a particular context, land, plant health, and that may require a genuine and sufficiently resourced support from different parts of government and potentially from private sector as well. I've been discussing some of these arguments with colleagues that work. There are human rights advocates. They haven't been tested in court yet, but I think that can be an opportunity to see how that part of my work may be providing arguments and feed into discussions about whether or not international law can contribute to justice in a very concrete context. The other area of work that I wanted to share, which is the more speculative one, is about a reflection on the human right to science. And that is actually the first reference to benefit sharing in international law. It dates back to the Universal Declaration of Human Rights. And it is a right that, for how much it has been enshrined in different legally binding treaties, it exists. Many human rights lawyers don't engage with it, and the reality is that it has remained quite unclear in its content. It does, however, raise crucial issues about how the production of knowledge is crucial for the raising of material and spiritual standards, both for individual fulfillment, but also for the collective economic and social development. So it has both that individual and collective side to it. There have been efforts to spell out the content of this right on the human rights side, and I think what was very interesting for me was to look at how the elements that have been identified really can once again benefit from and be fleshed out if we think about the relationship with international biodiversity law, what it can offer both in terms of concepts and guidelines, but also lessons learned, where in practice science is not participatory, is not necessarily addressing priorities that are key for the vulnerable and it may not, the benefits of science may not really reach the people that may need them the most, or the people from whom we seek collaboration in fostering knowledge, but we never return to. And there have been two parts to that research. One has to do with the engagement of the traditional knowledge of indigenous peoples and local communities in international processes. So you may be aware that in the context of international climate change regime, in the context of an intergovernmental platform on biodiversity and ecosystem services, there is a recognition that the knowledge of indigenous peoples and local communities is an essential element of our collective understanding on the environmental challenges we're facing and the potential responses that we can provide. So there's been that understanding, and certain advances have been made in trying to respectfully engage in a more systematic way with traditional knowledge holders. And that area, I think, of practice can shed quite a lot of light about what we expect in terms of sharing benefits in terms of human right to science. And it really has to do with the notion of sharing, which has to do with agency, with the active participation of different individuals and groups, whether or not they are scientists themselves, whether or not they are actually advancing science, in the identification of what benefits may arise from scientific advances and how those benefits can be shared. And it's really about, once again, the idea of dialogue, of how we engage, and we need to understand what are the expectations about science, what are the priorities, what may be the risks, and how we can respond to those, including across different worldviews. This has also, however, intergovernmental implications and dimensions, particularly when we think about all the aspects of science that underpin international cooperation across many global development goals, and particularly the Sustainable Development Goals. A lot of what we're trying to do in terms of achieving the reduction of poverty, fighting climate change, education, has to do with scientific cooperation, with the exchange of information, with capacity building, with technology transfer. And it has a lot to do with international funding, how countries from the global north support efforts and support this cooperation across borders. And a lot of it is, of course, very much determined by funders as well, the way in which the priorities of science are determined, the modalities that are put in place or not, are very often donor-driven. And this is where I think that understanding of sharing benefits from scientific advancements come into place, in saying, well, this can't be a monologue. This needs, once again, to be a dialogue, and a dialogue where those that we expect to particularly benefit from science need to have a voice and need to contribute to the identification of potential benefits as well as potential risks. And to me, that had led to an identification of certain further processes in international law where multilateral institutions are stepping up, are realizing that those international obligations that already exist in relation to scientific cooperation or information sharing, they don't really realize themselves left to their own devices. Some of it can happen because of unilateral or bilateral initiatives, but really we never really get to a stage where we feel content with their implementation. And that's to do with, first of all, the need for dialogue, to make sure that we're responding to the needs of those countries that may find themselves at the receiving end of funding or technology transfer or capacity building. We need to understand their priorities, and we need to identify together ways in which we can effectively identify benefits, share them, and assess any gaps or progress. So very much a learning process, a dialogue where, again, we may work across different cultural worldviews or ideologies, and yet we need that overview, and we need that dialogic and iterative engagement to understand if international law is making a difference or not. And this is an area where I hope that some of the ongoing international negotiations may be the test of whether those arguments may be helpful. And as colleagues also at the Strathclyde Centre for Environmental Law and Governance, we are involved in many of these processes. Now, this kind of thinking has then led, I think, me and other colleagues in the centre to start developing the idea of the One Ocean Hub. This is the new project that we're all embarking upon. As Douglas said, we're starting, it's a 5-year initiative, and it's very much to do with tackling the multiple challenges that affect the ocean, and really looking at the fact that we have one ocean, it's all interconnected. We may have divided it up in many different ways in law. We may understand it in our personal relations and in our own social interactions as different parts, but in fact, it is just one ocean. And I think what I'm hoping to do with this project is really to further test some of the work on equity and fairness in relation to different sectors of society, particularly looking at the question of natural resource development and conservation vis-a-vis the human rights of indigenous peoples and other local communities that may live in close proximity and in a close relationship with the ocean. But I think with further challenges that we have on land, partly because we have studied, I think, the use and the conservation of the ocean much less than we have, and we have used, I think, tools that we're quite familiar with, be that planning, environmental impact assessments. We have practiced and reflected upon them much less than we have for their own respective use on land. But there's also implicit connections there between what we may do locally and nationally and what is happening globally and regionally, and how different levels of governance come into play and have a role also when we look at very localized situations. So in a way, the aspects of the relationships between governments, business and communities, and intergovernmental relations, forms of cooperation that may be at the international or regional level, are much more intertwined when we look at the ocean than when we look maybe at the use of terrestrial resources. So there'll be a question of looking at multiscalar equity issues, and again, how international biodiversity law and its interface with international human rights law may help us to identify both certain limitations in the current law of the sea and other areas of international law that have to do with the oceans. But also looking further afield, and you can see how many other colleagues are involved in this project, and really wondering about how other sciences, and the point that Douglas raised at the start, how engineers and marine scientists can help us both understand what's really at stake, what kind of justice issues we're looking at if we think about the interconnectedness of the ocean, and all the things we still don't know about how our own life and well-being and future on Earth depends on marine biodiversity. And so just to give you a sense of what the hub will be about, it's research that combines law and policy with arts, with marine sciences, and with social sciences. And the idea is really, first of all, to understand better which forms of life exist in the oceans. We actually know less about oceans than we know about outer space. And also, what are the values that different people, different groups may allocate to those resources, and how different groups may be differently affected by our mismanagement of marine resources. It's trying to understand through the work of our colleagues engaged in ethnography about the existing struggles and injustices around oceans, and trying to push for research methods and tools that can be more inclusive of that variety of different views, worldviews, and values related to the ocean. So really trying to push for more participatory and integrated modeling approaches, for economic planning that can really take into account maybe values that may not be easily monetized, or they may have to do with different cultural approaches, and looking at cultural heritage and what has been done historically with the oceans, artistic relations, more spiritual relations, and understanding what's often falls through the crack of national level economic planning, but may have important innovative aspects in terms of creative economy, in terms of social innovation and solidarity. And ultimately working with artists, not just as colleagues that can help us convey what the ocean is about and how important it is for us, but really to understand how we can convey and how we can support an emotional connection with the oceans themselves, with their challenges, and with research on oceans. So through that, how will then human rights and biodiversity law come into play? And that's where there'll be not only an application of the research that we have carried out so far, but really a bit of an experimentation about how far that research can apply to ourselves, to researchers. And one aspect of it, which we have now discussed with colleagues across different disciplines and across different countries, seem to resonate, is that the idea of looking at the interface between biodiversity and human rights helps to frame and to find a common thread across different disciplines that look at the same issues in very different terms. It helps us to discuss issues and identify problems with colleagues that work on environmental justice, but it also helps us to discuss these issues with marine scientists that understand the values of biodiversity and can see how that is crucial for human well-being. It's also a frame then that helps us connect the findings that will arise from all these areas of research with different decision-making fora. Once again, understanding through that there may be decisions that can be taken at the local or national level, but there may be decisions at the level of regional fisheries management organizations, or more globally, that can very much affect and be determinant of the kind of justice and legal developments that we can try and achieve at the local level. And finally, I think the part that I think I'm more interested in is really looking at that idea of the right to science and what that means for academic research, for how researchers collaborate with each other, for how our academic practices and protocols really allow for fair partnerships between researchers in the global north and in the global south, with how we can really work with traditional knowledge holders, with women, with youth, and have them increasingly being not only our co-researchers, but actually taking the lead in taking forward the research, in shaping the future research agenda, and using the research findings for their own initiatives, be those advocacy or maybe social innovation. So it's really about wondering how this idea of looking at the relationship between biodiversity and human rights can help us look into what needs to change in research and research practices for it to lead to transformative change, for it to lead to something that is a true dialogue across different ideologies. And I'm becoming more and more aware of how different disciplines, and within each discipline we have our specific view of the world, and that can limit our understanding of connections in the natural world across sources of knowledge, and ultimately how we can truly collaborate and develop a new kind of science base that can really affect at as early stage as possible then decision making and ultimately decisions about natural resources and the ocean and conservation. So I'll leave it at that, and I look forward to your questions.